cases that are on the panels, and we thought that, as was just said by the SRSG, the panels and the cases are not just panel on the wall, they're not just pictures, they're human stories. And what best to bring those human stories to us and illustrate a few of them that you will be able to see afterwards, than having with us those who actually brought them to life in the courts. I would like to invite our first speaker, Jarvis, the Deputy Head of the International Impartial and Independent Mechanism for Syria, to take the floor. Michelle has been one of the leading global prosecutors on sexual violence. She was the Deputy Prosecutor for the International Criminal Tribunal for the former Yugoslavia and the Mechanism for International Criminal Tribunal, and she acted as counsel in a series of cases before the ICTY and the International Tribunal for Rwanda, making significant, groundbreaking advances and leading to criminal precedent. Michelle, you have the floor.
Well, thank you very much, and good evening, everybody, Excellencies, Your Royal Highness. It's really a great pleasure to say a few words on the occasion of the launch of the exhibition. And having had a chance to look around the exhibition a little bit earlier, I was really struck personally by how many of the developments that are displayed on the walls of the exhibition I have tracked over the course of my career. And of course, that comes with a bit of alarm to realise how many years I have piled up somehow. But certainly in October last year, I marked 25 years of working within UN accountability mandates addressing conflict-related crimes, from the Balkans to Rwanda and more recently to Syria. And my work on issues concerning women and armed conflict started even before that as part of an innovative research project in the mid-1990s in Australia, led by Hilary Charlesworth and Judith Garden. And the research was exploring the distinctive impact of conflict on women and girls, and the extent to which the law responds, or perhaps at that point in time more accurately didn't respond. But I remember very well the pushback that we got at that time in the mid-1990s, before the Women, Peace and Security agenda was even adopted. The pushback about the very idea that men and women experience conflict differently. Then, of course, gradually, stories of mass rape in first Bosnia and then in Rwanda began to surface, and these provided a horrifying illustration of exactly why a gender lens is so important when we're looking at armed conflict. But even with the dawning of this new consciousness around conflict-related sexual violence, the operational challenges that we faced in delivering justice for victims and survivors was immense, including, we have to admit, our own biases as justice actors. I saw a very clear example in 1997, starting out as I was then as an intern, assisting Paddy Sellers with an assignment for the AKSU case before the Rwanda tribunal. The AKSU indictment, as many of you will know, did not initially include any charges of sexual violence. The trial started and women called to testify began spontaneously speaking about rapes during the genocide. So Judge Navi Pillay, who was presiding, adjourned the trial and told the prosecutor to assess whether to amend the indictment. My task was to research whether it was possible to charge rape as genocide. Back then, this was a very novel idea and extremely controversial, with fears being expressed that if we were to charge rape as genocide, this would somehow water down the seriousness of genocide. In the end, the indictment was amended, and it led to the very first convictions in history for rape as genocide. But a very different story was very nearly told. Then again, in the mid-2000s, I was involved in work to appeal a duo of trial judgments from the Yugoslav tribunal examining sexual violence in Kosovo. And in these trial judgments, the court had artificially isolated out the sexual violence acts from other violent discriminatory acts and in effect imposed higher evidentiary standards leading to acquittals. These problematic precedents were ultimately corrected on appeal, but not without significant internal pushback first about the idea of appealing. In 2017, as I moved into my role as Deputy Head of the then newly created International Impartial Independent Mechanism for Syria, we were reminded of the need to keep disseminating the lessons learned. In Germany, an indictment in the Ruslan case for torture and mistreatment in a Syrian prison charged rape as an ordinary crime, separating it out from the broader pattern of crimes against humanity. Through advocacy efforts by people like Jravis and Lily Kappa, this was ultimately corrected and convictions were entered for rape as a crime against humanity. The Syria mechanism where I work provided evidence in support of the case, and more generally we've been working to situate sexual violence in Syria as part of the broader crime patterns as part of our structural investigation. So overall, we have seen successful interventions in individual cases that have helped to bring justice to victims and survivors.